All right, hi, and welcome back, Attorney Steve. I just came across this complaint. You may never have to take the SAT or the ACT. A lawsuit has been filed here. Very important breaking news. Now, this is December 2019, so it's just a couple months ago. I don't know what the status of the case is, but it's filed by the public counsel and a law firm basically individuals suing the regents of the University of California, Janet Napolitano, in her official capacity as president of the University of California, and Does 1 through 100. So basically, they are filing suit saying that the ACT test and the SAT test is not proper. It's discriminatory. It discriminates against people with disabilities. So here it is. Let's take a look at it. I am looking at this for the first time. This is very interesting news. I know a lot of kids know that they got to prepare for that SAT and they spend a ton of time, and the ACT, and I took the ACT myself, and years back when I went to Fresno State University. But here it is. So here you have allegations of violation of the state equal protection clause, discrimination on the basis of a protected class, prohibited discrimination in education under the California Education Code, violation of the Unruh Act. Say that, I like that one. Unruh Act. Okay, California Civil Code Section 51, and violation of the California Disabled Persons Act. So interestingly, they kept it in here in state court, which I found to be interesting. Seems to me like something that could have been filed perhaps in federal court, but there's probably reasons for that. But it's filed in the Superior Court, State of California, County of Alameda. Okay, so here it is. Let's take a look. Let's unpack this baby. Let's take a look at some of the allegations being made and see what we make of this here. So if public higher education is the gateway for all California students to build successful careers, pursue their intellectual interests, and gain meaningful access to social mobility. The California Constitution, established by the University of California, the UC, or university, as a public trust, and envisioned the UC as the culmination of the state of California. State is obligation to provide public education to its citizens. As the state's preeminent public institution of higher education, the University of California has a legal obligation to provide equal access to all qualified students, regardless of their backgrounds. But the UC has failed to carry out its promise. Rather than fulfilling its visions, an engine for opportunity for all Californians, and creating a level playing field in which all students are evaluated based on individual merit, the UC requires all applicants to subject themselves to SAT and ACT tests that are demonstrably discriminatory against the state's least privileged students, the very students who would most benefit from higher education. The discriminatory effect of the use of these tests is well known to both the state and the UC. Governor and ex officio Regent Gavin Newsom recently recognized that use of the SAT and ACT exasperates the inequities for underrepresented students, given that performance on these tests is highly correlated with race and parental income, and is not the best predictor for college success. UC Berkeley Chancellor Carol Christ similarly called for the UC to drop its test score requirement because SAT and ACT scores really contribute to the inequities of our system. Okay, so remember now, these are allegations. These are not necessarily fact. These are allegations that, of course, they're going to need to plead and prove, okay? So some people may wonder, I'm wondering, well, how do they distinguish who gets into college? And seems like that could mix up the whole setup. Maybe that's a good thing. I don't know. Put your comments down below. Let me know what you think. So here we have the California State Constitution. There's a federal constitution, but every state also has its own constitution. The state of California is a legal and political entity responsible for ensuring that all California public school students receive their individual and fundamental right to an equal education under the Equal Protection Clause of the California Constitution, Article 1, Section 7A. Of course, the federal constitution also contains what we call the Equal Protection Clause. And I'm going to do a video on that one day. It's been a while. I don't often delve into the constitutional area, but the Equal Protection Clause is a clause that I liked. It's a little complicated, but it's simple in nature, but complicated in application. So, but anyway, let's go on. Let's move it on down here. This complaint's about 100 pages, so I'm going to just scroll down. Once we kind of get the gist of it, I'm going to scroll down to see what they're looking for, and I'll let you guys be the judge. These comments are remarkably consistent with UC's original 1962 decision not to use the SAT because the scores add little or nothing to the precision with which existing admission requirements are predictive of success in the university. They are also consistent with the results of decades of research within the UC itself about the discriminatory effect and minimal predictive value of these tests. These discriminatory tests irreparably taint UC's ostensibly holistic admissions process. The mere presence of the discriminatory metric of SAT and ACT scores in the UC admissions process precludes admissions officers from according proper weight to meaningful criteria such as academic achievement, personal qualities, and requires them instead to consider criteria that act as a proxy for wealth and race and thus concentrate privilege on UC campuses. So again, back to the privilege issue. I guess they're saying if you're wealthier, you can afford tutors and which is true, tutors and extensive studying and things like that. So test guides, all that. So anyway, 3, consequently, the UC admissions process as deliberately operated by the regents creates formidable barriers to access to public higher education for deserving students from low-income families, students from historically underrepresented racial and ethnic groups, and students with disabilities. The requirement that all applicants submit SAT or ACT scores systematically and unlawfully denies talented and qualified students with less accumulated advantage a fair opportunity to pursue higher education at the UC. Every USC admission cycle that evaluates applicants based on their SAT and ACT scores irreparably damages the futures of tens of thousands of students who are capable of excelling at the UC campuses of their choice and benefiting from the opportunities and supports a UC education provides, causing unjustifiable squandering of time and resources and intense stress for them, their families, their schools. The UC is well aware that rather than providing meaningful information about a student's ability to succeed in college, SAT and ACT scores are largely a proxy for a student's socioeconomic background and race. Instead of measuring students' academic ability or mastery of curriculum, SAT and ACT scores reflect demographic and socioeconomic characteristics like family income, parental education, and race. With its mission of providing public higher education to all Californians, the UC would never explicitly decline to admit a student because the student is low income, a first-generation college applicant, or a member of an unrepresented minority group. But that is precisely the result of the UC's decision to consider SAT and ACT scores, an admissions process that rations access to public higher education on the basis of race, privilege, and wealth. Over the past 6 decades, the UC has commissioned study after study on what if at all, SAT and ACT scores contribute to the prediction of first-year grades and repeatedly arrived at the same answer, almost nothing. The similar conversation goes on, by the way, people, in regard to the LSAT for the law school exam. People spend thousands of dollars studying for the LSAT, tutors, everything, to get that high score so they can get into the top tier schools, the Ivy League schools, things like that. So just bear that in mind. There's a lot of different tests, of course. Taken alone, SAT and ACT scores predict less than 2% of the variation in the first-year grade point average. So it's not much of a predictor, they're saying. First-year grades are a dubious metric around which to build a student body. Nowhere in any of the voluminous publications and presentations about the UC system is it ever stated that maximizing first-year grades is either a goal of the system or meaningful in any relevant way to the objectives of college education. Putting aside the questionable choice to structure admission decisions around the metrics of first-year grades, UC findings have remained strikingly consistent over time. SAT and ACT scores add very little incremental validity to predictions of first-year grades. And That already marginal contribution dwindles even further once socioeconomic characteristics are taken into account. UC researchers have demonstrated that high school grades are consistently the best predictor of success, a finding that has also been established by hundreds of studies at other colleges and universities. Faced with such studies, the UC has not only admitted the considerable redundancy of using both high school GPA and SAT or ACT scores as admissions criteria, but has also recognized that high school GPA has less adverse impact on disadvantaged groups. Moreover, as the UC has acknowledged, but validity studies ignore, students can be coached to advantage on the SAT and ACT. The fact that affluent students can effectively purchase higher scores through expensive tutoring services diminishes the already limited predicted value of the test still further. The design of the SAT and ACT places underrepresented minority students at a significant disadvantage. Okay, so you get it. You get where this is going. I'm going to just let you go there. If you want to pause it, basically the highly discriminatory nature of the SAT has resulted in starkly disparate student outcomes. Okay, so you can pause all this if you want to read it. Bottom line, they don't like the test. These two tests, they don't think they're good predictors. They think it discriminates. And let's see if we can go to the bottom. This is really long, and I'll post the link to it in the section. But here's basically looks like some case studies. Gloria D. is a strong student. She has taken a rigorous caseload and has weighted GPA of 4.0 and an unweighted GPA of 3.78. Gloria D. aspires to be a doctor and has thus taken more science classes than her school requires, including an AP science class. She has received multiple academic awards and is a member of the National Honor Society. Outside of school, she volunteers as a hospital and as a dancer. She took the SAT twice. Once in the spring of her junior year, once in the fall of her senior year. As a student for whom English is a second language, Gloria D. has experienced difficulties with phrasing of SAT questions, including word problems in the math section. She takes a long time to read and understand each word problem, and when she realizes she's running out of time, she panics and guesses the answer. She has subsequently reviewed the word problem she answered in it correctly, only to realize that she understood the underlying mathematical concept but did not understand the question as phrased. Due to these challenges, she scored 1,110 on her first SAT, and so forth and so on. So you can read this story if you want. I'm going to post the link to this complaint so you can actually dig in if you really want to dig in and see some of the case studies it looks like they're quoting here. Take a look at it. But in essence, they want to get rid of these tests. If I go down to the very bottom and see what they're looking for, this is the prayer request for relief section. Plaintiffs request the following relief: injunctive relief requiring defendants and their officers, agents, and employees to cease requiring applicants to submit SAT or ACT scores to be considered for admission at the UC. So there it is. That's hitting hard. And boy, there's all these test prep companies and tutors and everybody else. So that's a case to watch here. I'll tell you what. Cease using the SAT or ACT scores in UC's statewide admissions index and any other pathway to guaranteed admission, and cease considering SAT or ACT scores in UC admissions decision unless defendants are able to demonstrate UC's ability to assess those scores in a rigorous, meaningful, transparent, non-discriminatory, and non-stigmatizing manner. A declaration that defendants, through their actions and omissions and the policies and procedures, violate the right to equal protection, government code, education code, the UNRU Act, California Disabled Persons Act, also seeking cost disbursements, attorney fees, and other relief. So there you have it, folks. Interesting case to watch. One of my brothers was in the UC system, and so it'll be interesting to watch and see, will these testing criteria, will they be eliminated? Will the LSAT one day be eliminated? Will these tests that you can pay for extra love, extra help, and nowadays even with ADD, you can get extra time on your test. You can get a full extra day. If your doctor says you have ADD, can't concentrate, you can even get a full extra day on your test. Things like this. Education is changing with technology, with further studies. We're learning more. What do you think? Put your comments down below. Tell me what you think. Be nice. Everybody play nice. And this is it. This is general legal information only. I will post the link down there if you want to read it. I found this to be a really interesting case, and hey, who knows, with some luck, you never have to take this test when you're done with high school. How about that? Anyway, have a great day. Hope you're having a good time. My battery's about to die. I gotta get out of here. Bye now. Attorney Steve Vondran. If you need more information, find me on the web at attorneysteve.com. That's attorneysteve.com, civil litigation, intellectual property law.